And my screen says preparing to live stream on YouTube Live. And now I have there we are. My screen shows a picture of us as we appear on the YouTube channel. How a random person goes about finding us is something I couldn't say. I think it is, well, there's a URL there. I'm going to minimize
If you click
that.
on YouTube, there's an option to copy streaming link, and then you can send it out if you want to.
So we are streaming now. No need of us to look at it on YouTube at the moment, but there may be somebody else in the universe who wants to. They should get a life. Okay. It is Post-Conviction Counsel's motion that we're hearing today with the state's opposition. And I have to tell you, Ms. Brandon, after reading your motion and the state's response and your reply, I am probably most interested initially in their contention that there's no authorization for me to order discovery at this stage of the proceeding. Would you like to begin at that point?
Sure, I can begin at that point if you want. I can also, if it makes sense to Your Honor, go through, there's sort of categories of items that we've asked for. Some of these things have already been disclosed. So at some point it might make sense to kind of bring us up to speed on what the remaining things are as well.
As you like.
Okay. I mean, I guess I'll just generally, just to at least address on the outset, Your Honor's concern. I mean, I actually find the state's position a little bit unclear about that. Whether there's a difference between a right to discovery or authorization of discovery. I mean, 11071, Article 11071 is a procedure for post-conviction review, right? And so the legislature created a whole procedure and a whole framework for there to be a full and fair adequate review of the legality of a person's conviction. So it doesn't make sense to me that the legislature would intend for a person's ability to obtain discovery or investigate that case would be stonewalled. And Article 11071 also doesn't prohibit Your Honor from exercising the authority to order discovery in this case. There is no provision in Article 11071, which is our framework, that says that you can't. But to that, if that's the state's position, at the same time, they have had an open file policy and they have turned things over to us. So it just seems consistent and fair at this point to keep going with that, to turn some things over but not others. Makes the state's position a little bit unclear to me. I think the best example of that is one of the final things that we asked for was a videotaped interview of one of the inmate witnesses, which just so Your Honor knows, that is one of the things that the state did turn over to us, and we did receive that. So we do have that disc and a copy of that disc. So that's, you know, an item that we asked for. It was in the motion and they gave it to us. What's interesting about the state's position on that, though, is that they state that the court should not order discovery where a simple written request would do. But again, it seems unclear what the state's position is, that what the state's ultimate position is on these things. So like, we're going in circles a little bit. Should we be filing motions? Will a simple request do? What the state wants or demands or how they expect us to request things is a little unclear. And whether they, you know, on their whim decide to turn things over to us has been a little bit inconsistent. So to that, For example, one of the most important things that I think that we've been asking for, that my position is a very simple request, is a list of veneer members that the state at trial and Mr. Falk agreed to release. So it is unclear to me why a simple written request would yield a disc of a videotaped interview, yet a simple written request would not yield the same. And so Your Honor knows that we did comply with this, the AG's request that we file a written request for the disc. And in that written request, we also asked for that list because it seems like a very simple, written request would yield a 1 or 2 page document, and they did not give that to us.
Okay, before we descend into the weeds, somebody's giving me feedback.
I hear feedback as well.
Before we get into the weeds about the technicalities of whether I have a quote unquote authority or not, maybe it's a good idea to discuss some of the practical issues around some of your requests. Did I not get the impression from reading your papers that the state says they don't have such a list? Or was I mistaken in that? Because if there is such a list, then we can talk about whether that should be discoverable or not.
I will respond, Your Honor. There is a list. However, it is as indicated in my email. And actually, if Your Honor would allow the ability to share the screen, I was hoping to be able to show you the transcript as to what I'm referring to. The crux of Mr. Falk's argument has been that this list was allegedly supposed to be entered into the record, and I do not believe that the record makes that clear. And so I would like to show Your Honor the portion of the transcript that I'm referring to, if someone who is a host could enable my screen sharing capabilities.
So, Ms. Brandon, are you okay? I didn't mean to pull a rug out from under you there, but we might as well just jump into the list issue.
I think that's fine. Yeah, I think it makes sense at this point to perhaps go by each category and see where we are with each one and whether that's been turned over, and if it hasn't, what our argument is for obtaining it.
And let me just observe that I can imagine the state saying at some point, we don't mind you having items 1 through 10, but number 11 is burdensome, and for whatever reasons, we do not want to voluntarily turn over item number 11. And therefore we invoke, you don't have the right to get it argument. Okay, so they're not necessarily, I don't condemn them. I don't condemn the state for being inconsistent. All right, so let's talk about the list.
So, I mean, I think it makes sense to present our argument first as our motion, but.
All right, you can go ahead and finish your argument, and then I'll let Ms. Findell reply with her transcript excerpts.
Okay, so yeah, so to answer Your Honor's first question, I think Ms. Findell did that they do have the list. So, I mean, our argument is twofold. It is, part of the argument is yes, that this was supposed to be part of the record, but also, I mean, just for sort of like fairness sake, right? Like there's something unique about this case that I think is important to point out, right? That at the time of jury selection, Mr. Falk was pro se, right? He wasn't represented by counsel. So this list is not in trial counsel files. I also don't think that the record is clear that there is a statement by the state at trial in volume 15 that we gave Mr. Falk a list. In volume 16, it says we presented him with a list, but I don't think that the record is clear that Mr. Falk was given that list and that he kept it, that they gave it to him to keep and that he has it. We have gone through trial counsel files. We have gone through the district attorney's file. And the problem is there's not really a way to know if it's the correct list or not. So this just seems like a really simple request. If this was something that purportedly Mr. Falk and the state agreed to release these veneer members, then why not just turn that list over to us so we know that we have an accurate and full understanding of what they agreed to. I also want to point out that the state, both at trial and in her response and in the AG's response, frame this as a list of disqualified members, of veneer members who would have been disqualified. There is no evidence in the record that these members were legally disqualified. I believe that the state has conflated legal disqualification with jurors who may have been challengeable for cause. And the state, yes.
Forgive me, I failed in my desire to get the stipulations on the record. For this record that we're capturing right now, we're proceeding with an electronic recording system as opposed to a shorthand reporting method. And it's my belief that counsel for both sides have stipulated and agreed that the record we're creating will be legally admissible or legally permissible, notwithstanding being the type of method it is, and more particularly described in an email that I sent all counsel yesterday. So on the record, if you would kindly address that. Ms. Brandon first, do you agree?
Yes, we stipulate to use of the electronic court recording device.
Ms. Vendel?
The state agrees, Your Honor.
Very well. Go ahead, Ms. Brandon.
So I just kind of want to make that clear too, that this was not a list of legally disqualifiable veneer persons. For example, if they had a prior felony conviction, this was people that the state deemed they may have a challenge for cause and got Mr. Falk to agree to release them. So that is an important distinction. If these people that we were able to identify were legally disqualifiable, then okay, that kind of clears things up. But if there's wiggle room, whether like these people were not legally disqualifiable, and there's a section from the record that I don't know if I have the capability to share my screen. So if Your Honor trusts me to read the record accurately, I'll do that. In volume 16 on the top of page 81, I'm sorry, that might not be right, but I'm sorry. It's volume 15 at the top of page 5. This is the state explaining the list, and I think that this is also the volume that Ms. Vendel is talking about. So in volume 15, the state attorney says, Judge, just for your information, we went through all the rest of them, the veneer members, last night. We gave Mr. Falk a list when he got here this morning of people that we believe, based on their questionnaires, are disqualified as a matter of law. And when he has had a chance to look at those, we'll make Ms. Flowers aware of those who are. And I believe that will speed the process up quite a bit, just eliminating those folks. Most of them are people that either do not believe in the death penalty, cannot participate because of religious reasons, or have already formed an opinion based on publicity. Those are not people disqualified as a matter of law. Those, once they're brought in for voir dire, have the law explained to them, may give rise to a challenge for cause. So I want to point that out because I think it's important. Now, whether the other part,
We lost you there. One of those moments.
Shoot, sorry, I'm sorry about that. Hopefully the last thing you heard was that, so I was reading from volume 15,
Yes.
where the state gives their reason. They say these are disqualified. Ms. Bendelford AG has purported that this was disqualified, but the reasons that the state gave at trial does not render those veneer members disqualified for cause or disqualified, legally disqualified. It may make them susceptible to a challenge for cause. So I think that's an important distinction here. Now, the other point that we've made is that, yes, this was supposed to be part of the record. And in volume 16, page 80, the state says, we presented Mr. Falk with a list yesterday of people. No, I'm sorry, I'm gonna back up. Ms. Stroud says, could I put something on the record before we go to lunch? Judge, we presented Mr. Falk with a list yesterday of people we believe were disqualified as a matter of law based on their questionnaires. And we've agreed, and he's agreed to that list. And so do you want me to just give you the list to put it in the record, or do you want me to read them off? Because it's pretty lengthy. And the court says you can present the list. So she presents the list to the court. So I think that that is clear enough that the state did attempted to and intended for this to be part of the record. And it would have made sense. If you present a lengthy list to someone who's pro se and they agree to remove a whole pile of people, it makes sense for that list to be part of the record. So whether this record is supplemented with that is an argument we're making, that the argument that the record should probably be supplemented with this. But regardless, it is such a simple request. I mean, I'll be honest, I just don't understand why the state is fighting so hard to turn over what is probably 1 or 2 or 3 page document that they have right now.
Don't let me hear their position.
Yes, Your Honor. And of course, I do want to address the authority question at some point. These are all wrapped up somewhat a bit with that question, but kind of going first to the point about disqualification versus qualification, I did not intend for that to be a legal disqualification. I was referring to the fact that in this particular voir dire, the way it was done is that they arrived at a qualified pool. So when I was referring to the disqualified juror list, I was not trying to intend or to mischaracterize or to otherwise obfuscate the list that's being referred to. Regardless, I still continue to disagree with their interpretation of the record. It is clear when Ms. Stroud and, that was the portion of the record I was referring to. This is 16 RR pages 80 to 81. I don't know if I still have the screen sharing capability. Okay, I do not yet. If Your Honor would like to see the transcript itself, I can pull that up, or I know she just read it, but sometimes it helps to see the visual part of it.
Well, I'm not sure what I have to do to give you the screen sharing capability.
So at the bottom of my screen, I see a share screen button. I don't know if you see that.
I do. There's a menu that says one participant can share at a time, or okay. Alternatively, multiple can share simultaneously. And then there are advanced sharing options. So I think you're good to go.
Yes. Okay. Here we go.
Before you do.
Yes.
If the record is clear that during jury selection, the state of Texas handed a list to the defendant, what would be the justification for denying him a copy of that list now?
If the record is clear, so I don't dispute that the record is clear, actually, that they did hand it to Falk. And I do disagree that they handed him the list overnight. The point was they wanted him to consult with his standby counsel if he had the opportunity to do that. And then they came back the next day and then read that portion into the record. Frankly, Your Honor, this is where we get into the authority questions. This is just not a general discovery right. It's not intended to be on the record. There's nothing there as far as like it's supposed to be an official document. In fact, it's quite frequent practice to provide shorthand lists essentially to a clerk so that they can go ahead and, for scheduling purposes, go through the disqualified jurors. It's not the state's burden to reproduce things that were already produced to him. And at this point, it is just general discovery. It does not fall within Brady. There's nothing about voir dire that is related to Brady material. And therefore, the question is, should the court be intervening in this way to reorder discovery where there is no authority to do so? We're not disputing the court's jurisdiction. However, authority has to be vested either constitutionally or statutorily, and neither are present here. There is no constitutional right to discovery. There is no constitutional right to post-conviction Brady, although as we noted in our response, there's a statutory right that actually does not apply here because his offense was prior to the Michael Morton Act, essentially the current version of the statute that applies post-conviction. Regardless, the state is mindful of its obligation and has been complying with it to the extent we have seen documents that are responsive under Brady. But a list of jurors simply cannot be. And the question here is, should the court be intervening in this way to give them a pre-discovery right where there is no statutory allowance for that? Article 1107 does not vest the court with pre-writ discovery. And the argument about there being an omission, essentially that it doesn't prohibit it, is belied by the fact that it does specifically talk about discover, but only in a specific context. And that is.
So there is a discovery right by statute that arises after the filing of the writ. We agree on that.
That's correct, Your Honor. After the filing of the writ, the state's answer, and the court entering an order designating issues for further evidentiary development.
And that's a list, I suppose. They can be amended. Just like the writ could be amended.
Your Honor, I'm sorry, in 1107-1, for non-capital 1107 cases, they can be amended anytime before the disposition of them. But under Article 11.071, there is no right to amend. This is it. This is our chance.
Well, thinking out loud, I can understand why having access to materials that the court ordered discovered would assist in the preparation of the writ. I can also imagine that if the allegations in the writ are broad enough, after it's filed, they could then seek discovery and be entitled to discovery of this list.
Yes, Your Honor. Oh, I'm sorry, I don't.
That's addressed to Ms. Vindell.
I'm sorry.
Yes, Your Honor, I would agree with that. Once they have filed their answer and we know what claims are at issue, then the court can determine whether specific discovery is relevant to their claim. I'd like to point out, Your Honor, we had a qualified pool and we have the juror questionnaires, and Mr. Falk has the juror questionnaires for all of those people. This is not impossible to discern from the record. It might take work, but you can compare the list of people who received juror questionnaires to the people who ultimately were considered part of the qualified death pool. That information is not unavailable somewhere. And they therefore could raise, if they believe that a particular juror was improperly challenged for cause, although it was by agreement by both parties, then that can be found from the record. They can raise that claim now, and if they want the list, then that would come up appropriately through the discovery mechanism that is provided within 1107 once this court has entered an ODI, or an order designating issues.
So I have to share an anecdote. When I was an elected judge, I walked into court one afternoon to preside over a discovery dispute. It was a nursing home death case, and the plaintiff's lawyer wanted a certain document involving the inspection of the nursing home. And the young defense lawyer, both of these guys had come in from the big cities to have this fight in my little country courtroom. And the war raged back and forth with citations to cases back and forth. And finally, a light bulb went off, and I said to the defense lawyer representing the nursing home, trying to conceal or avoid producing the inspection document, I said, is there such a document anywhere? Was there an inspection that was reduced to writing? paused a minute and he said, I don't know. So we're having this fight over legal principles. Well, he was kind of dumbfounded at that. I asked the plaintiff's lawyer, do you know whether it exists? No, sir, we really don't. But if it exists, we ought to be able to get it. So it's quite possible that it didn't even exist. We did not know that it even existed. So that ended the hearing, and I never heard from him again. Why did I say that? Why did I mention that little anecdote? What's that got to do with what we're trying to do here today? It seems like this may just be an issue of principle, because if they file their application, you know they've got enough what's evidence that such a thing happened, that there was a list, and that the defendant was inadvertently bamboozled into agreeing to it without the assistance of counsel or whatever legal theory they come up with. And if they ask for it after the filing of the application, assuming the ODI covers it, they're going to get it. So I don't understand why we're having this skirmish today.
Because it's just not authorized by statute, Your Honor. They have a discovery process within the statute, and the legislature has made clear exactly when and how they're entitled to information. And I will be clear, Your Honor, I have a typed list. There's nothing on the list to indicate this is the one that they gave them. I can presume that to be true, maybe, but it is a typed list produced by the state. And but for some reference at trial that this was given to him, it would be work product. So I am not 100% clear, or not 100% certain that this was the exact one that was given to Falk. And that is part of the problem. In fact, my opposing counsel said that earlier. There's no way to know what the list is because it wasn't supposed to be entered into the record, or at least it wasn't clearly the case that it was supposed to be entered into the record. And as such, I am having to look through work product files, which is where I found the list, to determine whether this is discoverable. And at this stage in the proceedings where there is no discovery right, it just does not seem appropriate.
Your Honor, may I reply at this point?
Yes.
So, I mean, there's a lot of things to address here. One, so this feels like a new argument, right? Like that is not what was in the AG's response, that all of a sudden this is work product. She said that there was a list that they identified.
She said that they're not standing on the work product argument because they gave him the list.
Okay. All right. So I just wanted to clarify that, you know, it obviously can't be work product because it was something already disclosed. But if the state is unsure if it's the list, I mean, it's the list that they came up with to give to him, and they have ways to know. Miss Starnes was one of the trial attorneys at trial. She knows that if it was the list or not.
I don't know that.
Okay. So that seems pretty easy to figure out. It also seems easier to figure out than requiring us to go through hundreds, literally hundreds of juror questionnaires, cross-reference them to names at trial, names that were on the schedule. There was also a 2-week break in the proceedings, and the schedule for the jurors got messed up. When, I'm sorry, but it would take the state a few seconds to email it, and then this could be done. I also disagree that the state sort of takes two positions. They say there's no right to discovery, but then they sort of slip into this term of it's not authorized. Those are two different things. And they have cited to no case and no provision of Article 11 or 7.1 that says that discovery, especially what we're asking for here, is not authorized. There is literally nothing that says that you do not have the power as the trial judge in this case, or the habeas judge, to turn something over, to order them to turn something over. There's no prohibition in any case law or Article 11 or 7.1. And then to that, I think a distinction should be made about what discovery is allowed. The ODI, so Article 1107.1 Section 9, which comes in if you're we file the application, the state files their answer. And if your honor deems that we, as the applicant, raise claims that merit further factual development, then you have a series of evidentiary tools available, a hearing, affidavits, interrogatories, to order further factual finding. So the ODI is sort of limited to what we raise and whether those claims merit further factual development. So it's kind of a chicken and egg problem. We have a duty as post-conviction counsel to do a full investigation, and I don't see how we can raise claims until we know if something exists, right? So it requires.
Hang on, let's pause there. I was waiting for that argument to come up. Your duty as post-conviction counsel. It doesn't necessarily follow that because you have a duty to represent him thoroughly in post-conviction matters, that the law allows you pre-writ discovery. Your duty does not drive legally permissible procedures. Do you understand what I'm saying?
I understand what you're saying. I mean, I do respectfully disagree with it, but I do follow.
Let's take an example. What if we had a statute that said there is no right to pre-application discovery? Okay. Could you not stand up and say, aha, that's unconstitutional because we have a duty?
So I hope I'm not coming off as flippant, but thankfully we don't have that statute. That isn't our statute. There is no, bar
Yes,
on that.
you are right, but that's another issue. I'm simply addressing your argument that has come up multiple times so far in this case, that writ counsel's duty seems to drive the actions required by the court under law. And I'm addressing that in a generic way to say, I don't think that necessarily follows. Now,
Your Honor.
oh, I know what I was trying to think of. Surely this is not the first time this problem has come up in 11071 litigation in the state of Texas. Do we not have any court cases on pre-application discovery?
I mean, I'll be on, from my knowledge, no. And I think that the reason for that is just because of the procedural nature of them. Like Texas is quirky and that we litigate everything in the trial level. And then, the Court of Criminal Appeals just sort of reviews the writ record to determine if the findings in fact and conclusions of law are supported by the writ record. And so I think that sometimes these types of things don't really make their way up into being litigated. So as far as I know that they haven't, but to address your concern about that, I mean, I think that there's it's not just that our duty to investigate, right? We have this duty to investigate, and that, part of what 11071 allows us to do, I think it's section 3, is to, ask for things like funding for experts in investigation and file pre-application motions to facilitate that investigation. And the only reason, and I bring this up because again, it's a chicken and egg problem, right? We can only raise claims that we have a good faith basis to raise, and we have to investigate those. And if the opposing party has evidence in its possession that would that is relevant and to a possible claim, I think they should turn it over. It also just makes sense. It doesn't make sense to require us to file a claim that, like right now, we have what's in the record is that they gave him a list of people. If those people should have been disqualified as a matter of law, or there's no reason, like, why force us to raise a claim just so we can get a list? It also just isn't very judicious to require things to fall in that line when all they have to do is literally email the list.
May I add something to that, Your Honor? I mean, I think the other thing that, that also applies here, while 1107.1 does not specifically lay out, discovery proceedings, 1107.1 is still under the dictates of the Constitution and under due process. And I think due process would, in a case where we're, seeking discovery, of something that is relevant to the claims, that constitutional claims that we are bringing, due process would also apply here as well. There are one Supreme Court case that comes to mind is Evitz v. Lucy, I think, where it applies due process to a post-conviction pattern, and there are several others, and those were listed in our reply to the state's response.
Your Honor, if
So
I
I
may
think due
respond.
process overrides in this instance, even if it's not specifically enumerated within the statute that discovery rights exist. If there is something relevant to constitutional claims we are investigating and looking to bring in our application.
Your Honor, if I may respond.
Yes.
What is specifically enumerated is that due process does not require discovery, and it also does not require a Brady post-conviction right. That has been made clear by the Supreme Court, so this due process argument simply it falls flat. The due process in post-conviction proceedings means nothing more than an opportunity to be heard, and that does not transform into a discovery right. Going back to Your Honor's question earlier about whether there are cases about pre-writ discovery, pre-writ is post-conviction, and post-conviction is not allowed in 39.14 of the Code of Criminal Procedure. It is clear that under the version of the statute applicable to Mr. Fox's case, there is no post-trial discovery right, statutorily or constitutionally. There are a couple cases, Ex parte Medina, where Judge Newell concurs, and he specifically notes there's no constitutional right to discovery. In Ford v. State, that is, I cited these two in my response. They're all in my response, but in Ford v. State, it was noted that Article 39.14a allows discovery and inspection of the material evidence sought by post-conviction or by an inmate when requested before or during trial. Here, the motion was filed after trial, and it was therefore untimely. The argument that just because there's no explicit statement saying that this court doesn't have authority is not how the law reads. In Staley v. State, it makes clear that it must be authorized, not that it's just merely absent. And that is especially true when you look at the legislative intent and the structure of 1107. There is discovery mentioned. It was not an overlooking of a discovery right. It was specifically contemplated and then enumerated in a particular part of the process. We can't look at that absence now and read legislative intent into it where there is no constitutional right and no other statutory guarantee.
Your Honor, I'm sorry, like, here's just kind of bringing things into focus a little bit, if it's okay. Again, they're not citing anything that says that you do not have the authority to grant discovery. I'm not hearing any authority, any argument or any case law, any statute that says you do not have the authority as the habeas judge to order discovery. This is a case where a person pled guilty, uncounseled, received a death sentence, and now he has his one full fair chance to determine the legality of his conviction. And it is odd that we would not have access to materials that might rise to challenges to his conviction. It just doesn't make any sense. And so I just want to reiterate, like, kind of bring to focus that this was an uncounseled guilty plea where the man got a death sentence. And this is our shot. We cannot amend the application. There are so many limitations in federal court. This is our shot to investigate and learn what claims may arise, may exist, that bear on the legality of his conviction and death sentence. This is our one shot in state court. And that should override this nitpicking of, we have a document but won't give it to them.
And I think too,
Give me just a moment. I'm trying to read in 11071 where the discovery right kicks in. Cite me to the statute, Ms. Stendo.
Section 8 and 9, where it discuss about fact findings with and without an evidentiary hearing. It delineates that at that point, the ODI can be entered, and if there are issues designated as controverted factual issues, the court can determine the method of fact finding. And that would be the only reference to any kind of discovery or entitlement to facts or evidence, excuse me.
So what is the language in 11071 that you point to that authorizes even post-application discovery?
It would be in section 9, subpart A. And in there is where it mentions that if the convicting court determines that controverted, previously unresolved factual issues material to the legality of the confinement exist, the court shall enter an order not later than the 20th day after the last date the state answers the application, designating the issues of fact to be resolved and the manner in which the issues shall be resolved. And it specifically lists several types of discovery mechanisms, including affidavits, interrogatories, and a hearing. Those are the only references to any type of fact finding or evidentiary development in all of 1107.
Your Honor, I would argue that that lays out like the procedure for what should happen next, right? It makes sense that when someone files a habeas application, you then have to figure out what to do with it, right? The state files an answer controverting those issues and the issues are controverted, then it lays out a framework for how the court can resolve those issues. But I still do not see how that prohibits someone from being able to learn before they file their application whether claims exist.
Your Honor, if I may, again, the argument.
I could be confronted post-application with the argument that there's nothing in the statute that enumerates production of documents. There's only affidavits, depositions, interrogatories, and evidentiary hearings.
Pursuant to the.
I could be confronted with that argument, apart from your concession you made earlier that if this was post-application, it would be fair game.
You could, but you wouldn't be here, Your Honor. If there's a hearing, then all the standard pre-hearing rules apply. We do produce documents for witnesses that are called. If the prosecution was called, we would produce documentary evidence. That's often provided far in advance, the same way that with an ineffective assistance of trial counsel claim, they waive, for example, the trial counsel files to the extent that the claim waives the topic therein. And we produce those documents ahead of time. We produce the expert disclosures ahead of time. That is how the process will typically go.
That's not in the statute. The statute doesn't say you're entitled to trial counsel files when, like that's what we're talking, at what point do we say that, we bind ourselves to what 11071 says? Like, it doesn't say that you're entitled to documentary evidence if there's an IAC claim raised. That's a framework for the proceeding so that the court can do fact finding, but nothing says that there is no right for either side to have to produce a discovery to the other before or after.
And Staley v. State by the Court of Criminal Appeals, the citation for that is 420 SW 3D 785, explicitly says that if it is not explicitly authorized, then there's no right or authority to it. So that logic follows. However, it's not what's done. What's done when there is a hearing is we produce documents pursuant to witnesses that will be called. There is no pre-write or any similar even extension of that logic pre-written.
I think too, I think we may have gotten, with regards to this jury list, far afield of whether or not it was put into the record. When the state says from the beginning, we want to put this into the record. I think at that point, if it's part of the record, then, we don't even get to this discovery discussion. And I think the transcript there in 16, page 80 to 81, I think it's clear that the state was seeking to put this into the record.
Again, Your Honor, I disagree with that characterization. It was clear that the state asked the judge whether he would prefer that it was entered into the record or whether it was just given to the clerk or whether the names were read off. The judge chose neither of those options and instead said, please present it. And then they just entered the list. Again, I think a matter of courtesy, and that is kind of the issue here. The argument that we're being inconsistent in our positions is not true. This is the difference between what is constitutionally required, what is statutorily allowed, what the court has the authority to do, and what the state does as a matter of courtesy. We have provided Brady material to the extent we can even do that by giving them, for example, the investigative list, although it was previously disclosed. We did that as a matter of courtesy. We have the open file policy as a matter of courtesy. We have given them 7 boxes of digitized states files. I think it's just flatly different issues.
None of which included, anything having to do with this list, which you say that you have.
I am not disputing that, Your Honor.
And
I'm
it's
all the arguments I've been making.
It's difficult to understand, what could be the issue with this list that you don't want to turn it over when you have it. It's there, it's in the record here, mentioned many times. It was turned over to Mr. Falk, but it can't be found in the record anywhere. It can't be found in any of the files that we've been given anywhere. So it's a little bit difficult to understand what the reasoning is, unless there's something harmful in there.
I reject the insinuation that we are trying to hide the ball here. I merely have made the arguments I made all along. I have a list. I cannot be sure about it. It was in work product. There is nothing indicating whether this was the one that was provided, and absent a requirement under the Constitution or a pre-writ discovery right, we are not obligated to turn that.
You quoted from a Court of Criminal Appeals decision. Would you give me the citation again, please?
Yes, Your Honor. It is Staley v. State, and the citation is 420 SW 3D 785.
So it's difficult to hear on Zoom sometime. Did you say Daly or Bailey?
Staley, that's Staley.
And read again the relevant holding in Staley.
That could be found at the PIN site 796. And they note there, this is not an 11071 case, but it's discussing the difference between authority and jurisdiction. And it says, aside from the provision permitting reexamination, the statute does not authorize the trial court to take any other action with respect to a defendant. And it notes that there is a difference in both. They must both be affirmatively vested. My opposing counsel was correct to say earlier, there isn't a ton on 1107 just because of the way the mechanism is kind of laid out. By the time it gets to the CCA, these disputes are typically resolved in the lower court. So there isn't a ton of CCA law kind of discussing the nuances of it.
Your Honor, I would like a chance to read this case, but just going over, this case seems to be so irrelevant to 11071 really off, just very different. This is like dealing with whether the court had the authority to enforce.
Hang on.
Sorry, I'm sorry.
I'm going to order the production of the list.
Okay.
Sometimes judges have to stop lawyers from talking when they've already determined that that lawyer is going to win. Okay, where should we go from here?
Let's see. Okay, let me get my bearings here for a second. So the first category was, I'll just read what it was. Any and all information and documentation in the state's possession relating to District Attorney Stroud's discussions with members of Mr. Falk's family. Since we filed this motion, the AG's office did disclose, I think it was maybe a 9-page document that, is that right? Had the notes from this trip. The prosecution took a trip to Tennessee and interviewed members of Mr. Falk's family. And then, so we're given this 9-page disclosure that has notes from, like, I guess what they learned from those conversations. The last 2 pages are redacted. And so I have sort of 2 requests related to this category. One is that Your Honor would conduct an in-camera review of the unredacted disclosure to determine if any of it is relevant to, for us, and if we're able to obtain that. So that's one part. The other is, there is nowhere in the reporter's record or clerk's record from the trial any mention of this, but at a post-conviction hearing about a year and a half ago, District Attorney Stroud said that when she returned from Tennessee, she sat down with Mr. Falk and disclosed to him what she learned on this trip from interviewing his family members. And she said that she did this because some of what she learned was Brady. So there is no Brady disclosure in the clerk's record, in the reporter's record. There's no record of this Brady disclosure. And so the other request is that any information that they obtained from witness interviews, whatever they believe to have been Brady, to disclose that now, because it is not in the record. And the only thing I'll kind of add to this is that, it seemed that it was the state's practice to do Brady disclosures on, in the clerk's record. At least there are other Brady disclosures. At least February 23rd, 2017, there was, I think that's the final actual Brady disclosure. So we're asking for whatever they deem to be Brady that is not in the record.
Okay, let me make sure I hear the facts correctly here. Was it during voir dire or a recess during jury selection that the Tennessee trip took place?
Yes, so there was, at one point, Mr. Falk expressed his intent to proceed pro se, and that was in the middle of jury selection. The parties took a break at jury selection. At that time, Mr. Falk was evaluated for competency to, for whether he was competent to waive counsel. And then I don't know what else happened, but there was this 2-week break. At least in the reporter's record, you have like February 1st, and then the next volume is February 13th. And those, somewhere in that time span, I believe in the state's disclosure, the dates were February 7th, 8th, and 9th. That's when the state went to Tennessee. They returned, and it seems like it was still during voir dire, really pretty promptly after their trip. They sat down with Mr. Falk in the courtroom and discussed this trip in the interview that they had with his family.
And how do we know that?
We know that because in October and December of 2018, we had some post-conviction litigation and in some hearings. And at that hearing, one of those hearings, I believe it was in October of 2018, Stephanie Stroud testified. She testified. Because at that point in time, we had raised some concerns about prosecutorial misconduct in this case at that time. And so we had some litigation over that. And Stephanie Stroud testified, and she told us on the record, and I have the transcript, I'm happy to share it, that she went to Tennessee, interviewed members of his family, came back. She says immediately sat down when they returned to court, immediately sat down with Mr. Falk and told him what his family supposedly told her. And this was still during jury selection. And her stated reason to us at that hearing, that's on the record, is I talked to him like I would any other lawyer. And I'm sorry, I'm paraphrasing, but this is it. I talked to him like I would any other lawyer. Some of it was discovery, and some of it, I believe, was Brady, and I had a duty to disclose that. So that's where we learned that this trip was made. That's where we learned that, that there was this conversation with Mr. Falk, and that her position was that there was discovery and Brady. And I have not seen anything. And when I did a review of the district attorney's files, there was nothing in there about this trip. And the disclosure that the AG gave me after I filed this motion is not in the district attorney's file. And there's nothing. And so where's this Brady?
Okay, so they've given you the 9-page document that was produced as a result of the Tennessee trip, but they have redacted was it conclusions or summary or something that was in the document? I
think it might say summary summary, and then it's all blacked out. But that's sort of separate. I'm also just wondering, like, is there a whole host of other stuff that they learned that they felt like they needed to share with Mr. Falk? There's just nothing in the record of a Brady disclosure.
Hang on just a minute, please. I have to deal with my daughter calling in here. Hi, Beth. Listen, I'm in the middle of So does this document, I'll call it the Tennessee document, bear a date?
I believe it has the date of it has a couple dates. It has the dates of their trip on it. And then it has handwritten I believe in the right-hand corner, that it was given to Stroud on, February 9th or 13th, but that would be in 2017.
Okay, so it was obviously prepared prior to the notation of that date.
Of the day that Ms. Stroud told us that she did the,
If I may, Your Honor.
It's got a notation in the margin that it was given to Falk on X date.
no, not Falk, I'm sorry, to Ms. Stroud. I don't think it says, the notation doesn't say it was given to Mr. Falk. It says that so an investigator prepared this document and gave it to the District Attorney Stroud. There's no notation that it was given to Mr. Falk.
Yes, Ms. Findell.
That's correct, Your Honor. The document was the investigative report prepared on February 2017, February 11th, and the notation indicates that it was provided to Stephanie Stroud on February 13, 2017.
So is that the middle of trial?
It was during the voir dire portion where there was the short break while they were investigating his competency.
Okay, since you got the floor, what is your objection to discovery of this document or the redacted part?
So there are two things. One of them I'm not quite clear on. The second one regarding some other version of stuff we have not disclosed. We only have the report. That's why we disclosed it, even though it was clear on, at least from Stephanie Stroud's testimony at the post-conviction hearing, that she did discuss this with Falk. There's nothing requiring a written Brady disclosure anywhere. So the fact that she testified under oath that she spoke with Falk during voir dire is sufficient, especially when there was no Brady claim at issue at the time. Regardless, regarding the redacted portion of it, it's less than a page, double spaced, and it's specifically entitled summary. I can represent to the court that every fact in that section is within the report itself. Everything else is explicitly comparing and contrasting the information learned on that trip with the affidavit provided by the mitigation investigator. And that is squarely work product. It is clearly impressions and strategy as to what they think it did and did not confirm, and they're not entitled to the investigators or the prosecutors' impressions of that testimony. The facts underlying them are disclosed in the report that they have access to.
Ms. Brandon?
Well, if part of it is comparing and contrasting other facts, then it seems like it's just more facts that are in there. But also, it's unclear to me what Ms. Stroud deemed to be Brady material. If it's comparing and contrasting what they've learned, then in theory, they either learned something new or something mitigating or something exculpatory that they would deem to be Brady. And if that's contained in that summary, then that should be disclosed. But regardless, we're asking for an in-camera review of that at least.
So that's where I'm going. What's the state's position on sending the unredacted and the redacted version to me with so that I can conduct that in-camera review?
I can do that if the court orders it. We probably send it via mail so that you have the physical copies of it. But
I'd like to do that. And if, not if, but I will suggest to you that you're welcome to supplement the points you've made, provided that you copy the opposing side on it. If you understand what I'm saying, you can say, you can see from the document that we've given you that it's clearly work product in lines, blah, blah, blah. Or whatever else you need to do to make it clear to me why you think it should be shielded from discovery.
okay, so either the letter, for example, maybe the cover letter that I provide you, which I can copy counsel on, or just
Yes.
another filing, for example.
It doesn't have to be another filing.
Okay.
Unless you choose to make it one. All right, let's move on. Oh, by the way, when can you do that, Ms. Findell?
I should be able to do that within the next day or two. It'd be done by the end of the week at the latest, but I should be able to send it by tomorrow.
Tomorrow. Okay.
And Your Honor, I at the risk of, beating a dead horse. I do have to remind everyone that, our habeas application is due Monday. And, I know I sent an email that we did ask for an extension, but gosh, there's just no guarantee that they'll rule on it on time. And we have to prepare, we are filing on Monday.
Doing the best we can.
I appreciate it. Thank you. And then I think that Ms. Vendel was maybe asking about this, but to the extent that there is any other information that the state at trial deemed to be Brady, we would, ask for that too, since I understand that there's no requirement of a written disclosure, but it's clear that that's how the state proceeded at trial, was to do written disclosures that are in the clerk's record. So to the extent that there was a disclosure, if they identify anything else that the state at trial deemed to be Brady, and that's why they decided to talk to Mr. Falk directly about it, we ask for that material too.
Well, you've got everything except the summary. And so I suppose I can review the summary to determine if it constitutes written Brady material or not.
Mm-hmm. Or if it appears that there's more somewhere. So there's two things, I'm sure everyone will be glad to know that there's two that I think we can take up together. One is information regarding weapons assigned to correctional officers and the serial numbers of those weapons, and materials relating to any decision to limit or halt the investigation into the offense. At this point, for the one relating to the weapons, the AG's position is that they found notes, but that they're work product. And for the second one, the AG's response says that they found notes created at trial, but it doesn't say whether they were created by attorneys or not. So I'm just wondering, I would seek clarification on whether it's attorney work product or not, or whether they're notes relating to the investigation. So for those two categories of items, our position is, again, that Mr. Falk's due process rights to a fair trial and to not be convicted and sentenced to death based on false testimony trumps the state's, any purported work product privilege. But the other thing that I'll point out is these two categories of materials, if they yield anything, would relate to potential false testimony claims. And in a false testimony claim, the applicant has the burden to show that the state knew, or they have to show that the state knew or should have known that the testimony was false. So kind of hard to know how to prove that at this point, but if there's anything that the state has that would show that prong of a false testimony claim, then the work product, any work product claim would yield to that. If they put on false testimony and they knew it or should have known it's false, we have to show that. So I think a work product privilege would yield to that. So we believe we're entitled to under those two theories. That said, we would ask for, at a minimum, an in-camera review of the notes. The AG said that they did identify notes. So what we're asking for is, one, anything that we haven't gotten yet related to those two categories, the weapons and reasons why the investigation was halted. If there are other notes or work product that the AG has identified under those two theories, we believe we're entitled to them. But at a minimum, we would ask for an in-camera review. They've already identified the notes. They should be able to send those to you. So we would ask for an in-camera review of those.
Okay, Ms. Vendel.
Your Honor, again,
Hang on. Mr. Fuller, did you have something to add?
Oh, I was just gonna ask, and anything in there that's exculpatory or impeachment evidence as well under Brady within those notes. But
Okay, Ms. Vendel.
again, Your Honor, this goes back to the question of the discovery statute. It explicitly, even if to the extent it does apply in these proceedings, explicitly exempts work product. All of the notes are handwritten notes by the attorneys during the Martin trial, during Falk's first trial, and during Falk's second trial. They're clearly the attorney's impressions of the witness testimony or of evidence that OCFW and Mr. Falk already have. They've already admitted that they possess a lot of the actual evidence related to the gun logs, the picket tags, or the picket records, the evidence tags, and the DPS submission forms. They're explicitly listed in there, and then the attorney writes their own impressions. It is clearly preparation for trial or during trial. This is not subject or disclosable to Brady. Impressions are not evidence. And work product is explicitly exempted from discovery rights.
And so how do you feel about the proposition of me doing the in-camera review?
We would object on the basis of this being work product, and that is clearly not, again, there is no authority for discovery here, but if Your Honor wants to order that, we can send that as well.
All right, send them to me for the review. Now, when I use the word them, let's make sure we're clear about what them is. What do you believe it is, Ms. Findell?
I have 16 total handwritten pages with regards to the weapons, and then 7 pages with regard to the accident reconstruction.
Is that the so-called investigation that was halted?
Yes, Your Honor, it was from the first trial.
And so do I need any documents relating to the weapons that were assigned, like logs, et cetera, or are they included in these 16 pages?
These are only notes that are purely work product. I have not kept back anything else that was offered or provided at trial. These notes do nothing but record the attorney impressions and preparation of the evidence that is available at trial.
All right, Ms. Brannon, is this what you're seeking?
I think that it is. If it's related to, if the notes are related to the weapons issue and any indication that the state was aware of the issue, the problems with it, then yes. And then for the materials relating to the decision to halt the investigation, if it's notes, whether it's investigator notes, DPS notes, anything in the trial, in the DA's file, in the AG's file, or even if it's their attorney notes, if it's related to that, then yes.
All right, send me the 16 pages and the 7 pages. Tomorrow?
Okay, yes, Your Honor.
Is there something else we need to do today that we can do today?
The only other category is that there's a series of letters that the state, again, one of these post-conviction hearings that we had, the state indicated that that Mr. Falk had written, quote, dozens of letters to the district attorneys. That would be District Attorney, then District Attorney Weeks and District Attorney Stroud. I believe, but I don't know that he wrote Ms. Starnes many letters, but one letter. So there are, we don't have dozens of letters. Trial counsel file, the district attorney's file did not yield dozens of letters. So we just, ask that to any letters that are in the state's possession that Mr. Falk wrote to them, we ask to have access to those. I understand this is a case where Mr. Falk was pro se at one point, but for the first trial, he wasn't. For a lot of jury selection, he wasn't. We do have some letters that he wrote after trial. So we were able to find, 3 or 4 letters written after trial. And then we have found, I believe, one other letter written to Mr. Weeks in 2014 that was in the recent disclosure, the boxes that that the state gave us. But so they have turned them over they've been willing to turn them over. So I just ask that, you know, if they find those, when they find those, that they just continue to disclose those. I do believe that at one point there was actually with the prior judge, Judge Countess, I believe at one point he actually ordered the state to turn those letters over to us, and we never got those. Is that?
That's incorrect. My recollection of that, Your Honor, is that Judge Countess ordered the state to produce those to him, and he reviewed them in camera, and then did not order them to be disclosed. I know that I turned over my one letter that I received from Mr. Falk, and I was there when Ms. Stroud turned over some letters to Judge Countess for his review in camera, and that is the last we heard about the letters. I don't believe they were ordered to be turned over. I
Well,
think he reviewed them.
then
and
this is the first time we're hearing about that. So if Ms. Starnes and Ms. Stroud were there physically present with Judge Countess to turn those letters over, then that was ex parte. We were not notified that those were turned over. We were not notified that Judge Countess reviewed those and made a ruling on them.
That happened at one of the writ hearings that you were present for. He just went in the back of the jury room and she turned them over, and then that was it.
That did not happen.
Hang on. What's the state's position on reproducing copies of these letters from the defendant, first trial and second trial?
Frankly, Your Honor, I can't see how it could possibly be Brady material if it was provided by the defendant. This is information stemming from him. He is charged and was well aware of every bit of content that he was writing to any of these prosecutors. But regardless, I represented in my response in opposition that we have not discovered any letters that are outside of the state's file. So I have nothing else to reproduce. I verified they're in the state's file that we disclosed to them, so they have access to all of it.
Very well. So you're not resisting the disclosure of any letters that you are aware of the existence of?
If I was aware of the existence of more letters outside of what has been already provided to them, I would still object on the basis that it is not Brady material and there is no discovery right. But I am not aware of any other letters.
If there are other letters known or discovered, I'm imposing a duty on you to make the court aware and opposing counsel be aware.
To disclose the letters themselves or just to make it aware? Okay.
Make aware of their existence
Yes, Your Honor.
by sufficient description that we can have some certainty, like letter dated such and such date, undated letter, 3 pages, total comprising 76 pages, for example.
Yes, Your Honor.
One can easily imagine that the writings of the defendant might disclose all kinds of imaginings or mental processes that need to be considered.
That's right. I think that's with the last request that we had was a videotaped interview of an inmate witness. That is the only witness we have identified outside of Mr. Falk and his co-defendant, Mr. Martin, that had a videotaped interview. But so the state did disclose, they did send us a copy of that disc, 2 copies, I think, and we did receive that. So that's the only one we've been able to identify exist. But if there are other audio taped discs, audio taped interviews with other witnesses in this case, we would ask to have those as well.
I personally am not aware of other videos. If I were to find them, these were always available to them. They were part of the state's file, and only but for coronavirus, essentially, where they were unable to go, they would have had access to this in person. So if I do discover them, I have no problem providing them further copies.
So is there something else I need to rule on today?
I I think that's it for us. And, you know, we are fine, you know, we'll be working on, today's Wednesday, we'll be working on Friday and Saturday, Sunday. So, you know, if after Ms. Vendel is able to turn those documents over and the court is able to look through those and does deem, you know, we are fine receiving those at any time this weekend before we file on Monday.
All right. Both sides may already be aware of this, but out of an abundance of caution, let me tell you that I discovered in a document file on my computer yesterday the findings of fact that I signed in the Martin case after the Court of Criminal Appeals wanted a hearing to determine the voluntariness of his request to end all of his appellate proceedings. So I presided over a hearing where Martin came and testified that he wanted all appellate to stop and the execution to proceed forthwith. And following that hearing, I signed off on this set of findings. So if anybody has a concern about that or wants to see a copy of it, you're more than welcome. I can produce it. I can't imagine how it's germane to this case, but that's for somebody else to decide.
If Your Honor wouldn't mind, if it would be easy enough to email the parties a copy of those findings, that would be good. We'd appreciate that.
That's fair. I'll do that.
Thank you.
Okay. What else today?
That's it for us, I think. Is that Mark, is that right?
Yeah,
Okay.
I think we're all set.
All right.
He has nothing further, Your Honor.
All right, then I'm going to end the hearing that I originally thought would be less than an hour, and I ran it over till, what, hour and 45 minutes. Good evening, all.
Thank you, Judge.